must all stand. The Royal Commission is now in session. Please proceed.
Thank you, Commissioners. First witness this morning is Lavina Laboya, who's already here in the witness box.
I swear by Almighty God
I swear by mighty God
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Have a seat, Ms. Laboya. Can you state your full name for the transcript, please?
Yeah, Lavina Mulekaloboya.
And have you prepared a statement for the Royal Commission, which is dated 10 October 2019? And do you have a copy of it there? Does it have a code in the top right-hand corner, WIT.0551.0001.0001?
Yes.
Have you had an opportunity to read that recently?
Yes.
Yes. Are its contents true and correct?
Yes.
Attend to that statement, Commissioners.
Yes, the statement of Ms. Lavina Laboya of the 10th of October will be Exhibit 11-67.
Thank you. Now, Ms. Laboya, can I ask you to read from paragraph 3 of your statement, please?
My name is Lavina Mulekaloboya, and I'm 21 years old, and I live in Western Australia. I'm currently employed as an assistant in nursing at a residential aged care facility. I was born in Congo and lived in Zimbabwe for a while. I speak 4 different languages, and I spoke a little bit of English before I left Congo. Then I took some English lesson while living in Zimbabwe. I came to Australia in 2007, and I did some more English classes after arriving in Australia. My path into working into aged care. During my high school, I did work placement at hospitals and an aged care facility. I liked my experience in aged care more than the hospital. Then I completed a Cert 3 in health assistant as part of my high school diploma. After graduating from high school at the end of 2014, I started studying nursing. Whilst I was studying nursing, I worked as an assistant in nursing. I did not finish my nursing degree and switched to a biomedical science degree. During university semester breaks, I did a Cert 3 in aged care. I always wanted to help people, so I thought the aged care would be a good way to begin my career. In 2018, I took a year off my university studies and worked full-time in aged care, and I haven't gone back to university at this stage. My experience of working in aged care. I started working in aged care at the beginning of 2018. My first job was casual, but I wasn't getting in many shifts, so I started working for an agency. In about June or July in 2018, I accepted a casual position as an assistant in nursing with my current employer, who I'll refer as the First Facility. The First Facility is located in suburban Western Australia, and it has 5 wings, including a dementia wing with 20 beds. There are 68 residents in total at that facility. And in about June this year, I started working at a second facility, which is also in the suburban of Western Australia. This facility has 72 beds, including a dementia wing with 16 beds. I refer to this as the second facility. I am employed as a casual at the first facility, and at the second, I'm a permanent part-time, and I have 8 shifts a fortnight. My minimum contracted hours are 59 per fortnight across both facilities. I would normally work between 60 to 65 hours. Since I started my second job, I usually work morning shift at one facility and afternoon at the other one. Every day is different. The morning shift starts around 6 a.m. to 7 a.m. My role is to be on the floor and help residents with their activities of daily living, answering bells, and generally assisting with anything the residents need. Some residents need assistance with feeding, so I would assist them with breakfast and later with lunch. In the afternoon shift, I go through the afternoon routine, which involves things like checking that all the residents are hydrated and repositioned. At the first facility, I also shower residents who prefer an afternoon or an evening shower. And at dinner time, again, I assist some residents with feeding and then change the residents into pajamas and get them ready for bed. The night staff come in around 10 p.m. and I do a handover. And at both facilities that I work, there are currently 3 assisted in nursing, 1 registered nurse on the duty across the facility on the night shift. When I work in the morning shift, I feel like there's never enough time and I'm always on the clock. At the first facility, there are 12 assistants in nursing and 3 nurses, 1 enrolled nurse in the dementia unit, and a registered nurse for the whole facility, and another enrolled nurse who helps the registered nurse with the 48 residents that are upstairs, in the upstairs wing. The second facility has 2 nurses on duty, 1 registered nurse and 1 enrolled nurse, and 10 assisted in nursing for the morning shift. And the enrolled nurse works in the dementia unit. During the morning shift at both facilities, there isn't enough time to spend with each resident. And the other staff and I spend each around 10 to 15 minutes with the residents, and we're constantly rushing. The afternoon shift at the first facility is different from the second facility because the second facility, there is no showering residents in the afternoon, but it's still very busy and I feel rushed. Management and rostering. At the first facility, we have a part-time manager and a clinical manager. The rostering is done by someone in head office and she isn't on site. We get the roster sent through on the computer, and as a casual worker, they roster a specific amount of shifts and then I can pick up any additional shifts I'd like to work. Sometimes they don't put me on the roster and I would have to ask for all my hours. At the second facility, there are 2 schedulers who are admin assistant. They work out the rosters in 6 weeks blocks and they allocate a certain number of shifts to staff as permanent shifts, and they make up the additional staff numbers by letting people put their names down for any additional shift they want to work. I do 8 shifts per fortnight as permanent shifts, and the maximum amount of shifts per fortnight is 11. The schedulers then approve the additional shift, and not all shifts are always get picked up. If nobody puts their name down for the free shift, we just work short, and we are short-staffed at the second facility about 3 to 4 times each week. At the second facility, about 80% of the care staff are permanent part-time, so they work the same shift each week, and the other 20% are casuals. At the first facility, around 50% of the care staff are part-time workers, and the other 50% are casuals or from casual pools. If you're part of the casual pool, you work across multiple facilities. Sometimes when a staff member is sick at the first facility, they call someone in from an agency company, but sometimes it takes a while for them to arrive. And other times they ask someone from the next shift to start earlier than calling someone from the agency. This means we're sometimes short-staffed. At the second facility, they do not use agency. So if someone calls in sick, the registered nurse has to try to get someone else to replace them. But if they can't find someone, we just have to work short-staffed. For example, if someone calls in sick for a shift for the next day, it will go through the rostering schedulers and they will try to replace the shift. Sorry, one moment. However, if someone were to call in sick after 4 p.m., the schedulers have gone home, the registered nurse has to call around and try find someone to come in. If they can't find someone, they just have to work short staff the next day because they don't have to use agency as the second facility. When we work short staff, consideration about safety goes in the bin. Even though management are aware that we are short, it feels like they expect for us to make miracles. And safety is not considered. It is really hard working short staff in high care as a lot of people who are 2 assists, which means they have to use 2 staff for part of their care needs. In particular, you need 2 people to lift them in or out of the bed or a chair. At the first facility, the staff are more vocal. They'll refuse to do tour assists if there's not someone to help them. So management will try to find staff to make sure we're not short-staffed, because otherwise families will complain. At the second facility, staff are less vocal, and they'll work as a team and help each other, so people will move between wings to help other staff with their double assist when they are short-staffed. It is very hard to look after your resident when you have to go to another wing for a good 20 to 40 minutes to help the other staff with their double assist. It means that my residents have to wait and I can't help them, for example, needing to go to the toilet and then it will happen in the pad. I have raised concern about staffing numbers multiple times at the first facility with the clinical manager and the facility manager. I have complained about the issues like being on the floor in what we call the heaviest section, which is the wing with more residents that are double assist, with no partner to help. Staff come from other wings have to come from other wings back and forth to help, but would only stay for a few minutes before going back. In my experience, when I've raised these issues, there's always an excuse. At the second facility, a registered nurse told me that she has raised the issues of understaffing in writing, and later got that the scheduler had to got back to her and said that we have enough people on. The other issues that affect the staff at both facilities I work is the lack of equipment. We don't have enough equipment, or the equipment is faulty. We put tags on the equipment to advise that it's faulty, but it may not be fixed. For example, at the first facility, we only have one hoist that can weigh all the residents. We have to run back and forth with the one weight hoist across the facility. There are also problems with the hoists used to transfer the residents. Many of the hoists are old and do not go high enough to get the residents off the bed properly. So we still have to lift the resident, and it also leads the staff to having to pull the resident off the bed into the chair because the right equipment isn't available. Training. At both facilities I work at, we have ongoing training that we do fortnightly or monthly. At the first facility, most of the ongoing training have become online now, involving listening to someone talk in a video, then answering the questions. The training is compulsory, so if you don't do it, you won't be included on the roster, regardless whether you're part-time or you're a casual. We are supposed to be able to do the training during work hours, but often we're too busy. I try to fit the training during quiet times in my shift, but if a call bell rings, I would stop to go help the resident. At the first facility, there are around 2 or 3 compulsory training each year that are run face-to-face. The manual handling training that we have to do is not useful because it's unrealistic. It does not allow for the fact that some residents weigh over 100 kilos, so in a hoist that is not going high enough, you would need 3 carers to assist and end up pulling the resident. And if someone from head office comes to teach us about manual handling, it's based on the books and not on reality. Sometimes they train carers to deliver the manual handling to other staff at the facility, which is much better as they teach us with the residents and the equipment. Concluding remarks. Aged care is the end of a lot of residents. Despite that, I know that I can make a difference. A lot of the residents don't have family, and we're their only families. I get satisfaction in my job from seeing the residents smile and knowing that I've made a difference. I find that all staff are on the same page with me. My job is different every day, and you can never predict what will happen. I really like what I'm doing, but I'm not sure about the future. And the pay could be a lot better, but for now it's okay. I'm considering other options because I'm always exhausted after my shifts. My back and my shoulder are always sore, and I worry that if I injure my back while I'm young, I won't be able to get a job after that. A lot of the people I work with are much older than me, and they tell me to get out and save my back. If there were more staff and better equipment, I might stay in aged care, but management refused to acknowledge that there is a problem. They always just say that they have a budget, and it makes me feel like management don't care about the fact that work is often unsafe. It makes me feel like management. Sorry. If there was more staff, I would also be able to spend more time with each resident and maybe stay in aged care a little bit longer. Spending more time with residents would allow me to speak to residents and listen to their needs and not have to rush them. Some of the residents walk slowly. If we have more time, we can assist them walking to the bathroom. But because we are rushed, we must put them in a chair, then wheel them into the bathroom and save time. Thank you.
Ms. Maud, thank you, Ms. Laboya, thank you very much for giving your evidence. It helps the Commission understand the circumstances, the conditions of people like you, and it's good to hear from someone of your age. Thank you.
May the witness be excused, Commissioner?
Yes, you're excused from further attendance. Thank you.
Commissioners, I now propose to call the next three witnesses together as a panel. So I call Karen Cusack, Andrew James Brown and Shona Reid.
Please repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the
and
truth.
nothing but the truth.
I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Affirmation, please. Thank you.
I solemnly and sincerely
I solemnly and sincerely
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Ms Cusack, starting with you, you are the Victorian Health Complaints Commissioner,
That's correct.
and have you prepared two witness statements for the Royal Commission?
Yes, I have.
Is one of them dated 27th of August 2019 with a code in the top right corner WIT.0389.0001.001,
Yes, that's correct.
and the other statement is dated the 17th of October 2009 and it has a code WIT.0529.0002.001.
The one I have is not that dated. It's an earlier one dated the 11th of October. Sorry.
That 11 October statement was replaced by the 17 October statement,
That's
is that
correct,
right?
yes.
So we're just going to tender the first one and
Oh,
the
okay.
third one. Do you now have the statement dated 27 August and the statement dated 17 October?
That's correct,
Yes.
yes. Thank you.
And have you had an opportunity to review both of those statements recently?
Yes, I have.
Are there any changes that you would wish to make to them?
No, there's not yet.
Are
They
their
remain the
contents
same.
true and correct?
They are.
Yes. Tender both the statement dated 27 August 2019 and the second statement dated 17 October 2019.
And are you intending them for them to be the one exhibit?
I think they can be the one
All
exhibit.
right, well, that's two statements of Exhibit 11-68.
Thank you, Commissioner. Now, Mr Brown, you're the Queensland Health Ombudsman.
That's correct.
Yes. And you've prepared a witness statement for the Royal Commission dated 30th of August 2019.
Yes, I have.
Have you had an opportunity to review it recently?
I have.
Are there any corrections that you would wish to make to that statement?
Yes, there is. On page 7, at paragraph 32, there's some data there that's not correct. It states that my office has issued 16 interim prohibition orders, and that should be 17. and it says I've taken immediate registration action 7 times. That should be 6 times. And on the last page, paragraph 36, it says 11 practitioner matters. It refers to 11 practitioner matters. That should be 10 practitioner matters. There was one matter that we since identified as not being an aged care matter, but it was a high care disability facility.
Okay.
And that means that where it says 4 unregistered practitioners, that should be 3 unregistered practitioners.
All right. Is there anything else?
No, that's it.
With those corrections, is your statement otherwise drawn correct?
Yes, it is.
Yes. I tender that statement, Commissioners.
All right, the statement of Mr Brown with those corrections will be Exhibit 11-69.
And Ms Reid, you are the Executive Director, Performance, Education and Policy within the Aged Care Complaints Resolution Group at the Aged Care Quality and Safety Commission.
That's right.
Yes. And you've prepared a statement for the Royal Commission that's dated 9 October 2019.
Yes.
And it has a code in the top right, WIT.0528.0001.001.
Yes.
Yes. Have you had an opportunity to review that statement recently?
Yes.
Are there any changes that you would wish to make to it?
No.
No. And its contents are true and correct?
As far as my knowledge goes, yes.
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 I tender that statement also, Commissioners.
That's Exhibit 11-70.
Ms Cusack, starting with you, I'm just going to ask you some questions about the scope of application of the National Code of Conduct in Victoria. You administer the Health Complaints Act 2016.
That's correct.
And your office is established under that act.
That's correct.
Yes. And your office receives complaints about both healthcare professionals who are registered under the national law
Yes,
and unregistered.
that's correct.
Yes. What kind of complaints in relation to registered health practitioners is your office responsible for?
We receive complaints about the provision of health services in Victoria, but we're a health complaints entity under the national law, which means that where we receive a complaint about a registered practitioner, we must notify the Australian Health Practitioner Regulation Agency, or AHPRA. We then work with AHPRA as to which agency is best placed to deal with the complaint. So we'll notify, and if it's the complaint goes to the conduct of the practitioner, we'll refer the matter to AHPRA. If the complaint is about matters that don't relate to the registration or the conduct, we will usually deal with them within our office.
What kind of complaints might fall into that second
So
category?
where a person is seeking an explanation as to what occurred, where it might be about seeking an apology for something that happened, it might be a refund of fees. Those types of complaints can't be dealt with by AHPRA, so they'll be dealt with within our office. But we must still notify AHPRA at the outset that we've received that complaint.
Now, a person may complain to your office in relation to a failure to comply with the Code of Conduct by a general health service provider. The Code of Conduct, which is Schedule 2 to the Act under which you're established, is based on the National Code of Conduct for Healthcare Workers.
That's
Is that
correct.
right? Yes. And whether that code applies to a person working in Victoria depends on whether they fit within the defined term a general health service provider. Is that right?
That's correct.
Yes. And that in turn turns on whether they are providing a health service.
Yes.
Yes. And what types of services are caught within that definition?
In effect, the general health service providers, that code of conduct applies to all health services that aren't regulated by AHPRA. So of the 16 professions that AHPRA regulates, such as doctors, nurses, physiotherapists, etc., everything that falls outside of that fits within the general code of conduct if there is a provision of a health service. So, for example, massage therapists, cosmetic providers, a lot of alternative therapies, some allied health services such as social work, counsellors, that type of thing.
So the work that would typically be undertaken by a personal care assistant in a residential aged care facility, would that be capable of being a health service?
If it goes to the provision of the health service, yes.
So when your office receives a complaint in relation to the conduct of a general health service provider, is the first step for it to decide whether or not to deal with the complaint?
That's correct.
Yes. And what would be the criteria by which that decision is made?
So the assessment that's made is whether the complaint fits within the jurisdiction of the Health Complaints Act initially, and then whether or not there is another body that's set up to deal with the complaint. So we have powers to refer matters that relate to a disability service to the Disability Services Commissioner, for example. So if there is another agency that is established that can deal with the complaint, we won't deal with it as a general rule.
Okay. So if your office decides that it will deal with a complaint, is the process then to decide whether the complaint will be subject to a complaint resolution process or an investigation?
Yes, that's correct. But the bulk of our work and most of the complaints that we receive, we deal with through an alternative dispute resolution process. So very few of the matters that we accept to deal with as a complaint make its way into the investigation space. So we deal with most things through complaint resolution.
So what kind of matters would be dealt with by way of an investigation?
If we decide to deal with the complaint, we'll assess it whether it's suitable for a complaint resolution process. So if it isn't suitable for a number of reasons, it might be the seriousness of the matter, it might be that it is a voluntary process, our complaint resolution process. So if the provider, the health service provider, doesn't engage in that process, we may decide that it's still warranted to deal with as an investigation. So we will deal with it straight through into investigation. Some investigations may arise through as the complaint resolution process is established, so it can still be then moved into the investigation space. We have different staff doing investigations to the resolutions.
Are you able to give a rough indication of the percentage of complaints that will be dealt with by way of a complaint resolution process?
I can, well, the bulk of them. So for the last annual reporting year, we had just under, I think my statement says the exact number of complaints we received, but it was just under 6,500, and we did 38 investigations in that time. So it's a very small number that are actually investigated as opposed to dealt with through the alternative dispute resolution process.
Right. And while your office is conducting an investigation, you have the power to make an interim prohibition order for a period up to 12 weeks. What are the circumstances in which you can make an order of that kind?
The test is whether I'm satisfied that there's been a contravention of the Code of Conduct and that there's a serious risk to the health, safety or welfare of an individual or the public. And so that's the test for that. And we are able to make further interim prohibition orders if the investigation hasn't been completed within 12 weeks.
And then at the conclusion of the investigation, you have the power to publish either a health warning statement. What's the statement of that kind? What does that usually involve? That
is published in a newspaper, broadly circulating newspaper throughout Victoria and on our website. It talks about, it can name the health service provider and the circumstances of the warning. It will talk about the profession and where they practice.
And the other option is to make a prohibition order.
That's
and
correct.
What would be the effect of a prohibition order?
A prohibition order can prohibit all or any part of a health service, the provision of a health service. It can impose conditions. It can be time limited or ongoing. We publish that as well, so that's published in the Government Gazette in Victoria as well as on our website.
And is the making of an interim prohibition order also published?
Yes, it is. That's
including the name of the
name of the provider and the type of service and the conditions that are imposed, if any.
And when either an interim prohibition order or a final prohibition order is made, it's an offence to fail to comply with that order.
That's correct.
Has your office prosecuted any offences for failure to comply with an order?
We've prosecuted a provider who was banned in another jurisdiction and also providing services in Victoria, but we haven't prosecuted anyone for breaches of a prohibition order.
Made in
this stage.
Victoria.
Made in Victoria,
Yes.
that's correct, yes.
Now, you identify in your statement that since your office was established on the 1st of February 2017, you've received 67 complaints that were classified as involving a health-related aged care service.
That's
Is that
correct.
right? And your office made a decision to deal with one of those complaints.
That's correct.
And so the other 66, there was a decision to close the complaint without any further involvement from your office.
That's correct.
In relation to the 66 complaints that your office decided not to deal with, were they, a number of them closed on the basis that the complainant, it was suggested that they contact the Aged Care Quality and Safety Commission?
Yes, that's correct. That's as part of the assessment of whether we would deal with a complaint or whether there was another agency more suited to deal with it, and we would assist the complainant with how they went about that.
So you would provide information about the existence and the role of the Aged Care Quality and Safety Commission, but you would not necessarily yourself refer the complaint to that Commonwealth agency?
No, that's correct. The Health Complaints Act sets up, it establishes the referral processes for a number of what's defined as the relevant law, which includes the Disability Act, Mental Health Complaints Act, Privacy and Data Protection Act, and then referrals to to APRA. There isn't an ability to actually refer more formally to other agencies in the Health Complaints Act, which is different to the previous legislation that applied before 2017, where there was a broader power to refer to any agency.
So just to understand that, your understanding is that the referral power doesn't permit you to formally refer a complaint to the Aged Care Quality and Safety Commission?
That's correct.
But can you otherwise share information other than by way of a referral?
The confidentiality provisions that establish the obligations of confidentiality on my office mean that we can't share identified information more broadly unless there's an exception to that, and there are a number of exceptions within the legislation, and it sets out that if there is a serious and imminent risk, then the obligation of confidentiality is overridden. We can share information more broadly on the written authority of the Secretary of the Department of Health and Human Services, or if there's for legal means. But overarching obligations of confidentiality preclude broader referrals other than those set out in the Act.
Now, turning to you, Mr Brown, Queensland has also enacted the National Code of Conduct, but it's done so in a slightly different way. Your office is a single point of contact for all health service complaints. Can you just explain what the role of your office is in relation to registered health practitioners?
Yes, well, in relation to registered health practitioners, as you said, we're the single point of contact in the first instance for any complaints or notifications about a registered practitioner's health conduct or performance. When we receive a notification or a complaint, essentially our role is to determine whether our office should continue to deal with that matter or the matter should be referred to APRA. Now, the test for that is that the Office of the Health Ombudsman will retain the most serious complaints and notifications about registered practitioners, and those are matters that go to professional misconduct or whether there's another ground potentially for suspending or cancelling the practitioner's registration. And professional misconduct is defined as falling substantially below the standard that would be expected of a reasonable practitioner. So we make that assessment as to whether the matter is likely to be professional misconduct, and we'll retain it, assess it and potentially investigate it. Where it doesn't meet that standard, provided we consider it's not frivolous, vexatious, lacking in substance or trivial, we refer it to APRA to deal with.
And your office can also receive complaints both in relation to an individual health practitioner and a health service organisation.
That's correct.
And a health practitioner includes an individual who provides a health service.
That's correct.
And that definition of health service would be broad enough to include the work typically performed by a personal care assistant in an aged care facility.
Yes, that's correct. It's
Yes.
a very broad definition.
Yes. Now, your office has the power to make an interim prohibition order in relation to an unregistered worker. But in order for a final prohibition order to be made, there must be a proceeding commenced in the Queensland Civil and Administrative Tribunal.
That's correct, yes.
And how does the National Code of Conduct fit within the scheme established by the Health Ombudsman's Act?
I guess in various ways. For our office to take action against an unregistered practitioner, for the matter to be investigated and for an interim prohibition order to be considered, the test is that the practitioner's conduct, health or performance is such that they pose a serious risk to persons and it's necessary to act to protect the community. That doesn't necessarily sit particularly closely with the National Code. It's almost a separate test. Certainly failure to comply with the National Code might go into that test, but it's quite separate. So in those serious matters, we will investigate and consider IPOs. Where there are just merely, I guess, breaches of the National Code that don't meet that test, we can deal with them through a local resolution process, through, for example, reminding the practitioner of their obligations under the National Code, but a mere breach of that code wouldn't necessarily be actionable by our office.
Okay. Now, in practice, in the period since your office was established on the 1st of July 2014 through to the 30th of June this year, your office has received 856 complaints in relation to health service providers delivering aged care services.
That's correct.
And 410 of those concerned a health service organisation.
Yes.
And 567 concerned health service practitioners.
That's right.
So just focusing on that latter category, of those, your evidence is that 90 related to unregistered practitioners.
Correct.
Are you able to say what the roles being performed by those 90 were, or at least give a picture of the categories of worker that's...
Yes, I believe it's broken down in my statement at paragraph 29. Do you want me to go?
So it's 33 were in relation to assistance in
That's
nursing,
correct.
22 in relation to personal carers, and 9 in relation to aged care health workers.
Yes.
Is there anything technical about those categories? Is it possible that they might overlap?
Yes,
Yeah.
yes, it is possible.
Now, since the 1st of July, your office has issued, I think you said 17 interim prohibition orders, and 12 of those related to unregistered practitioners.
Yes, that's correct.
In relation to those 12, are you able to tell the Commission the category of the practitioner that the order was made in relation to and the nature of the conduct that was...
Yes, I can. I have it in a table, and if I just go through that table, I guess case by case, the first one was assistant in nursing, and it related to a health impairment that they had. Another one was a social worker that related to theft and fraud in relation to an aged care resident. Another assistant in nursing related to a health impairment, substance abuse. Another assistant in nursing, it was illegal conduct, burglary of the resident's room and stealing their property. Another assistant in nursing related to inappropriate administration of medication, which I understand to be spiking the resident's drink with unprescribed medication. Sedative, I believe. Another aged care worker was an assault of an aged care resident. Another assistant in nursing was theft and fraud relating to an aged care resident. Another assistant in nursing was financial exploitation of an aged care resident and a boundary violation. Another assistant in nursing was a substance abuse related health impairment. Another assistant in nursing was illegal conduct, theft of medication from an aged care resident and the employer. An aged care worker, it was unauthorised administration of medication. I think it was crushing up unprescribed medication and putting it in their food. Assistant in nursing, assault of an aged care resident. So I think they covered that.
Did all of the investigations that resulted in the making of those interim prohibition orders arise from complaints made to your office from members of the public?
No. Probably the largest source of information in relation to those matters came from the Queensland Police Service, either notifications from them, from investigating police, or more recently, we fund a position in the Police Information Service that does daily checks in relation to practitioners that may be charged with offences or under serious investigation. So that is a source of information for us, and I'm able to make an own initiative investigation. So that's probably the largest source. The next would be notifications by providers, and then finally probably notifications from colleagues.
Work colleagues of the
Yes, that's
individual
right.
concerned. And apart from the ways that you've just mentioned that your office receives information that then leads to an investigation, are there other ways that your office gathers information that might lead to the exercise of its own motion investigative power?
Additionally, there are complaints from consumers or family members. Occasionally, there will be, for example, media reporting of a matter that we're not aware of, so we'll make inquiries to identify the relevant information.
So your office will proactively monitor matters that might be
That's correct.
reported in the paper, and will follow those up?
Yes, if we don't already know about it.
Ms Cusack, just to ask you about those matters, does your office also have an own motion investigative power?
Yes, that's correct. There are 3 ways in which we can commence an investigation. That's following a complaint, if the Minister for Health refers a matter for investigation, or on own motion.
On your own motion. And do you have similar resources and relationship with the Victorian Police in relation to referral of information about matters that they might be investigating?
We do receive some information from the police, but not to the same extent, it seems, as my colleague does. We certainly don't have a position within Victoria Police. Most of the matters that we've received information from the police in relation to has been around boundary violations in the massage area. So that is where we've received the information from police.
Has your office ever followed up matters that might be reported in the newspaper? And
Yes, we do, but safe to say that we're generally aware of things that have been reported, and we'll often be asked for comment before a matter is reported, and we don't comment on ongoing investigations or complaint processes. But yes, we do. If we become aware of something, we'll certainly follow it up.
all right, now I want to ask you both about evidence that has already been received by the Royal Commission. It involves a complaint made by Ms Holland Batt, and there was evidence about this given at the Royal Commission's hearing in Brisbane. Could I ask the operator to bring up Exhibit 8-28? And could we just turn, please, to page 0008? And if we could just bring forward on the screen paragraphs 49 and 50. Isaac, I think you've seen this statement before. Are you familiar with the allegations that Ms Holland Batt made, in particular the allegations that are set out there in paragraphs 49 and 50?
Yes, certainly aware of them from reading the statement.
Yes. So Ms Holland Batt made a complaint to the Aged Care Quality and Safety Commission in relation to her father's treatment at an aged care facility in Queensland, and involved allegations that a carer had been seen leaving her father in a room for hours when he was awake and needed to go to the toilet, that he had deliberately moved her father's wheelchair away from his bed so he could not get up, leaving him immobilised and distressed, that the carer was alleged to have taunted her father and refused to shower him, and there was also an allegation that in the course of showering him she had neglected an obvious infection in his elbow, which resulted in him being hospitalised. If allegations of that kind were raised in a complaint made to your office in relation to a personal care assistant in Victoria, are they matters that your office would deal with?
On the face of it, no. We would assess it against the criteria I mentioned before, whether there is another agency that is better suited to deal with it, and we would assist the person to contact the Aged Care Quality and Safety Commission. In the case of, this is a whistleblower, I understand, that made this complaint. That would add a layer of complexity. We wouldn't suggest that a whistleblower should lodge the complaint with the Commission, although we would say that the Aged Care Quality and Safety Commission was available to them, but we might facilitate that and notify them. But as I said earlier, in relation to the obligations of confidentiality, we can't actually refer a matter, but we would suggest that the Aged Care Quality and Safety Commission was better suited to deal with that complaint.
And you understand that the focus of the Aged Care Quality and Safety Commission's regulatory function is the aged care providers themselves, and that it does not have any power to make orders in relation to individual workers?
Yes, I'm aware of that now, yes.
But do you nonetheless take the view that your office would not deal with this complaint, even though it does raise issues in relation to the conduct of an individual worker?
If the person is employed within the aged care facility, then that's correct. We would see the responsibility being with the oversight body for the quality and safety standards in aged care.
Mr Brown, the allegations made by Ms Holland-Batt related to care in a residential facility in Queensland. Has your office received a complaint in relation to these matters?
Yes, we have, very recently. The background to that was, for the Commission's information, that we first became aware of Ms Holland-Batt's allegations of elder abuse when it was reported in the Australian newspaper, I think a few days after she gave evidence before this Commission. A director in my office then made contact with Ms Holland-Batt. She was fairly easy to contact through her work, to advise her of our jurisdiction and to advise her that she could make a complaint to our organisation if she wished. She had another pressing family issue to deal with. She said she was interested and she would once she dealt with that issue. Some
to investigate?
the aged care worker is clearly within our jurisdiction. And I sort of speak generally on the basis that the matters now currently potentially will be under investigation. But taking those allegations at their highest, and if they are capable of being substantiated, then I would consider that they may fall within the serious risk category.
Does that mean there would be potential, subject to what the outcome of an investigation or the process of the investigation, that you might make an interim prohibition order in relation to conduct of that general kind?
Of that general kind, if it looks like it's capable of being substantiated, considering obviously the submissions that the practitioner would make in any procedural fairness process, including in this case probably the passage of a significant amount of time and what may have happened in the interim, then it is possible that that would be the basis for some type of interim prohibition order, either a full prohibition or there may be conditions placed on that practitioner's employment.
Thank you. Yesterday, the Commission heard evidence in relation to the conduct of an employee of Japara, who we're referring to as Mr. UA. Did you both have an opportunity to listen to or read that evidence?
Yes, I did.
Yes. Just very briefly, the allegations included that on the 19th of March, Mr. UA slapped a resident's hand and telling her that she couldn't have a biscuit. On the 12th of January 2016, Mr. UA was in effect rough whilst assisting a resident to undress. On the 3rd of March 2016, Mr. UA was said to have forced food into a resident's mouth after they had complained it was too hot. And on the same day, Mr. UA was said to have thrown a call bell device at a resident's leg. And then lastly, on the 16th of April 2016, Mr. UA was said to have shouted at a resident, threatened to break her walker, hit the resident on her face and sworn at her and stomped on her clothes. Just starting with you, Ms. Cusack, if allegations of that kind were made in relation to an aged care worker in Victoria, would your office take the same view that it would not deal with the complaint?
That's correct, if they were employed by the facility.
Yes. So again, you would just recommend that the complainant contact the Aged Care Quality and Safety
That's
Commission?
correct, yes.
Mr. Brown, allegations of that kind, what would your office's...
Yeah, it's a slightly different approach. I think looking at those allegations in their totality, if we got that all at once and we looked at that course of conduct, then my view would be that that would, if it could be made out, would be likely to meet the serious risk threshold, which would mean the matter would be investigated by our office and consideration would be given to issuing an interim prohibition order.
If those complaints weren't to be raised in one go but were to be made over a period of time, is there a mechanism within your office to monitor complaints to see whether there are multiple complaints being made about a single person?
Not necessarily. So if they start, some of the lower level complaints, I guess if you call it that, in that group of activity would be around the showering with cold water without testing it, the hot food. I mean, they're extremely concerning, but it's not as clear for us as to whether that would meet the threshold. If we just had those, I mean, we have we keep a record of that material on our system. So should there be any further complaints being made about that practitioner, that would be easily accessible by us, and it would be considered in any assessment process should further allegations come in. So those first allegations would take a fair amount of consideration by us as to whether the threshold was reached. We would look at things like their employment history and we'd search for any previous conduct on their part. But certainly as it progresses to the slapping incidents, I mean, we have and we will take action sometimes on one single incident of slapping a resident and liaise with the QPS as well in relation to whether charges would be laid. But it's a sort of a case-by-case decision.
But a pattern of conduct can potentially constitute a serious risk.
Yeah, we certainly look for that's something we look for.
Ms. Reid, to bring you into the conversation, I'm sorry to have ignored you. The focus of the complaints resolution group's complaints handling function is to deal with complaints in relation to approved providers. That's right, isn't it?
Yes, in relation to approved providers,
Yes,
that's right.
and so it's correct that you don't have power in relation to individual workers in aged care facilities.
That's correct.
The evidence that you've previously given to the Royal Commission is that the Commission in the 2018 financial year received 7,828 complaints.
Yes.
would the number be similar for the 2019 year?
Yes, it's tracking along, it's tracking that way. And I'd just also add that each complaint consists of about 3 or 4 different issues. So last financial year we dealt with over 18,000 separate issues.
And typically, is it right that about 30% of the complaints to your office are considered to be out of scope, so matters that you would not deal with?
That's correct. We do deal with them by referring to, where we can, the appropriate body.
Right.
Yes.
Does your office maintain data about the number of complaints that involve allegations about the conduct of individual, either registered or unregistered healthcare professionals?
Our system records topics or issues, and there is one key sub-keyword. I'll just say that we're reliant on our complaints officers putting ticking the right keyword, I guess, for the particular issue. There is one issue that is about personnel and behaviour, so we can run a report against that particular keyword.
Is it likely that a significant proportion of the complaints to your office would involve allegations about the conduct of an individual working in an aged care facility? Do you have a sense of how often that happens?
I think there was over 300, but I can't tell you exactly that sub-keyword, but I can get that for you.
Over 300 in 1 year, or?
Yes, one financial year.
Which year would that have been?
I think it's not last financial year, the one before. That particular keyword issue came up in the top 5. Last financial year, that particular keyword didn't come up in the top 5.
Right. And your office has arrangements in place with the various state health complaints entities for the sharing of information. At the moment, those arrangements take the form of an exchange of letters between your office or the predecessor agency and the various state entities. Is that right?
Currently, the previous Complaints Commissioner did have an exchange of letters. Since the 1st of January, when we became the Commission, we have an MOU signed and in place with the New South Wales entity, and we have a draft MOU that we're working on with Queensland, and we intend to do so with each entity.
And broadly, what will those MOUs provide for? What will be the arrangement for sharing of information?
Okay, so that they are an understanding, so a memorandum of understanding, and that will enable our staff and the staff of that entity to be able to have discussions and have discussions about what might be within their jurisdiction and what might not be each time. So those kinds of informal discussions. It will mean that we can meet and talk about our own types of issues that are across the sector. It doesn't mean, though, it also describes if we were to share information, it would be within their legislative framework and our legislative framework.
In the course of the letters of exchange with the Victorian Health Complaints Commissioner, I think in fact it was the predecessor agency.
That's right, yeah.
Were you aware before today that the Victorian Health Complaints Commissioner takes the view that complaints about the conduct of an individual in an aged care setting are matters that should be dealt with by your agency, not by the Office of the Health Complaints Commissioner?
I became aware once in a lead up to this commission. Before that, I didn't.
Is the consequence of that view that there's a gap in relation to the regulation of unregistered healthcare professionals in the aged care setting, at least in Victoria?
Well, we do take a number of actions, as you know, when we become aware, which is to advise the police or to ensure that the police are advised either by us or by the complainant or by the service provider, and the service provider ensuring that they make a mandatory report and we will make referrals to our quality and monitoring group, who will also look into matters, as you know, around human resource standards. Then it is open to us to also then refer to the entities as well. Sorry, what was your question?
But my question is just in relation to regulation of the professional conduct of the worker.
Yes.
At least in Victoria, it would seem there's a gap because it's not a matter that can be dealt with by your office, and the Victorian Health Complaints Commissioners doesn't
That's
deal
right.
with those matters.
That's right. So in Victoria, we would need to rely on the service provider taking disciplinary action or taking some action against their employee.
Yes.
Yes.
Now, complaints that are received by your office, are they regarded as protected information under the Act that establishes the Commission?
Yes. We collect a lot of personal information.
Yes. Is the consequence of being protected information that your ability to disclose that information is restricted?
Yes, we can share that information in the public interest. So if we felt that, again, it was about the safety or the risk of residents, then we can share that information under the Act.
Does your office consider whether it's able to share information with a state-based health complaints entity relating to the conduct of an individual worker, if that's raised in a matter?
Yes.
Yes. Does your office do that on every occasion where a complaint raises allegations in relation to the conduct of an individual?
I would say that more often we would advise the complainant to go to the appropriate body for unregistered worker conduct, and we would provide them with the information, phone numbers, and describe the National Code of Conduct to the complainant.
Do you accept that it's possible that a complainant in that circumstance might not follow up with the state-based complaints entity?
Yes. If they do sound reluctant or say, no, I can't do that, or I feel uncomfortable or whatever, we would think about getting an advocate to help them do so, and we can refer them to an advocate to do so, and we would do a warm transfer to an advocate, or we would consider doing it ourselves depending on the risk, how high the risk is.
Pardon me, depending on the risk?
We would consider doing that ourselves, yes.
Yes. So consideration is not always in every case given to exercising the power yourself to disclose that information.
That's right.
It depends on an assessment of the approach that might be taken by the complainant.
It depends on sort of a lot of factors and on the individual case and the risk. As I said before, our first thinking is to, if it is high risk, to ensure that the police have been advised that a mandatory report's been made. We would question the provider about what action they're taking to make sure people are safe in the facility. And that would be things usually like we've terminated the employment of the person, or we've moved them away, or we've suspended them, and they're under investigation. That would satisfy that immediate risk. And we would also make a referral to our quality and monitoring group. Then I think lastly, yes, we would start to think about referring to the state entity ourselves.
The assessment of whether or not you're permitted to share protected information with a body such as a state-based health complaints entity, it turns on whether or not there's reasonable grounds to believe that the person's conduct breaches the standard of professional conduct of a profession to which the person relates, and whether the person should be reported to that body. Is that the test?
Yes, it is. With a registered care worker, there is a clear code of conduct and clear parameters around referring a registered practitioner.
And do you accept that some matters that might involve a breach of the national code might not necessarily be matters of the kind that would warrant a report to the police, but nonetheless they might indicate conduct that has breached the National Code of Conduct.
Yes, they may not be a criminal matter.
Yes. And so in that circumstance, your office would have authority to share that information with a Health Complaints Commissioner.
Yes.
But as I understand it, your evidence is that you would not necessarily do that. It would depend on consideration of a range of factors.
Yeah.
Earlier this week, we heard evidence in relation to conduct of a number of people working at an aged care facility here in Victoria, in suburban Melbourne. Those matters were the subject of a complaint to the Aged Care Quality and Safety Commission. Could we bring up, please, tab 148 of the Menorock tender bundle? Well, perhaps it's not necessary to bring up the document. I'm not sure if you've had an opportunity to familiarise yourself with the evidence from Tuesday.
I did watch it, yes.
One of the allegations made in a complaint to the Commission was that a personal care assistant had forced an elderly person into a manual lifting machine where it was noted that he was a two-person assist. And in the course of attempting to get him to stand up in the machine, the allegation was that he'd had a stroke and partially collapsed, and the person had then lain him back down in bed and, in effect, left him. That complaint, as I said, was the subject of a complaint to your office. Do you know whether any referral has been made in relation to that complaint to the Victorian Health Complaints Commissioner?
No, it hasn't.
Do you accept that the allegations appear to at least suggest a breach of the obligation in the General Code of Conduct, in particular the obligation on a general health service provider to provide health services in a safe and ethical manner?
Yes.
Yes. Are you able to explain why that wouldn't then be referred to the Victorian Health Complaints Commissioner?
I know in that case there was a police report made, it was a police matter. I know about the disciplinary action from the service. I also know that we made a type 2 referral because we understood the risk of that immediately, and that type 2 referral to our quality monitoring group resulted in sanctions, as you know. It was open to us as well to make a referral to the Victorian entity. However, it wasn't done. I said in my statement that I need to go back and look at our guidance material and information and really find out, try and clarify the differences around the country, and maybe make it a bit clearer.
Clearer for your complaints
Clearer for our
officers?
complaints officers to know that they can do so. I know we're certainly clear in Queensland, not as clear in Victoria. New South Wales, we're clear. South Australia, I think we're clear. The other territories and states haven't implemented the Code of Conduct.
No. When you say you're clear about what the position would be with Queensland and New South Wales, is that to say that you would, if the conduct had related to an aged care facility in Queensland, you would have referred those matters to the Queensland Health Ombudsman?
As I said before, that's the other area. Our practice is to advise the complainant to do so, but in the case that you're just talking about, we didn't do that either.
Yes.
The advice, and that is on the on the thinking that it's first-hand information that's provided to the entity. So, for example, in the case of Ms Holland-Batt, her actual first-hand advice to the Queensland Ombudsman, in our view, would have been better than us doing that third hand. And she was very happy to do that, we thought. That way she would get feedback from any investigation that was undertaken.
Yes, but even if your office was to make the referral, further inquiries would then follow, which would presumably necessarily involve engagement with the individual.
Yes, you've heard.
Yes.
That's what would happen.
So really, once your office has sufficient information to suggest that it's able to disclose the information, whether that information is coming from you or from the complainant directly is not really going to make any difference to what the health complaints entity might do, is it?
You might have to ask them that.
Well, I'm just asking
Yeah.
you because
Yes.
you seem to think there's a distinction and that it's better that the information comes from the complainant directly. I'm just trying to understand why that's the case.
Our understanding is that if there was an investigation undertaken, much more information about that that investigation would be able to be shared directly with the person who has made the complaint. That's what I'm meaning.
Yes, but the referral would just prompt further inquiries, in effect.
Yes, if that person became the complainant in any investigation that might be undertaken.
Yes, that's right. But a referral from your office would be sufficient then, perhaps, to give rise to further inquiries with the complainant directly.
Yes, not from us, but yes.
Commissioners, I have no further questions for these witnesses.
Mr. Reid, I wonder whether I could ask you this question. Well, first of all, thank you for the information that you've given us. It's helpful. And I should indicate that I'm going to ask the others something a bit like the question I asked Ms. Reid. You've been in the position for a bit, and you've seen the way complaints get dealt with, some that come to you and some that go to other bodies. What do you think could be done better as an institutional thing? I don't mean by you, I mean how will the industry and the country be better served?
Okay, my own personal view, based
All I
on
can ask.
those circumstances that you said, how long I've been doing this role, I think it would be an improvement to have some sort of unregistered carer register, national register. I think that would help service providers be able to screen people that they employ to ensure that they're getting good quality staff.
And should it be, do you think, what role do you think there would be for state-based organisations in what you've just described?
I guess for them to be able to share it to some national register. I don't have a view on who would do that, but there would need to be some oversight body.
Yeah, and what about the standards generally? Do you think that they're identified with sufficient clarity and precision for the work to be undertaken?
Do you mean the National Code of Conduct?
For example?
It is very general and it's not very specific when we look at some of the areas of abuse that we've been talking about. Mm-hmm. For example, verbal abuse would fit within quite a general area of that National Code of Conduct. So for complaints officers to be able to understand that and see where that all fits, I think is not an easy task.
Now, you were asked some questions about sharing of information, and I think a lot of them questions might have been upon, or you might have understood them as being upon the assumption that it was thought to be a good thing. But I wonder whether, in your experience, there are difficulties about the sharing of information.
We have to be we have to be very aware and understand that on really reasonable grounds, and we've had experience with this with registered practitioners, to ensure that we have it is on reasonable grounds that we refer that medical practitioner or a registered practitioner to AHPRA. There can be obvious consequences if we don't have good reasonable grounds for that.
And what do you think your strike rate is like? Do you get it basically right or basically wrong?
I think we get it right referring. We haven't had feedback that we haven't referred well, but I can't comment on how many investigations AHPRA actually end up, or what actions they end up taking.
But does it mean that you're basically conservative or basically